Good morning, distinguished guests, members of the ICC, special invitees, ladies and gentlemen. Welcome to the third arbitration conference organized by the International Chamber of Commerce, Sri Lanka. My name is Purnima and I will be your MC for today. The International Chamber of Commerce is celebrating 100 years of the ICC International Court of Arbitration this year. Since the inception of the ICC Court back in 1923, they have remained at the forefront of supporting global trade and investment through dispute prevention and resolution. ICC was founded in 1919 in the aftermath of the First World War, at the time when no world system of rules governing trade, investment, finance, or commercial relations existed. The founders of the ICC were a group of industrialists, financiers, traders, determined to replace fear and suspicion with a new spirit of hope and cooperation. They call themselves the Merchants of Peace. ICC is an organization that represents business everywhere. A century after its founding, ICC issued a declaration on the next century of global business, setting out a vision to shape the future of global business for the next century. ICC Sri Lanka is the domestic chapter of the Paris-based ICC and was incorporated in 1955, providing important services which include creating policy commissions, and additionally, in respective fields of arbitration, banking techniques and practices, e-business, IT and telecom, financial insurances, taxation, transport and logistics, anti-corruption, and agri-food hubs. ICC Sri Lanka also issues ATA Kane, which is an internationally accepted customs document which enables duty-free and tax-free temporary interpretation of items such as commercial samples, exhibits at fairs, and professional equipment, and is also the issuer of Certificate of Origin in Sri Lanka. And now we have two videos of ICC Global and ICC Sri Lanka.
The International Chamber of Commerce Sri Lanka is the national office of the Paris-based business organization. The ICC comprises of membership of 45 million members in 130 countries. Trade facilitation, export and import and cross-border trade and issues relating to freight forwarding and many other matters of importance are addressed by the ICC. ICC Sri Lanka works through several committees to debate, discuss and suggest solutions on subjects related to the mandate of the Chamber. Each of these commissions are led by professionals in the committee, with many committees functioning. ICC includes a membership committee, International Relations Committee, Policy and Advocacy Committee, Training and Development Committee, Banking Committee. ICC is the sole authorized guaranteeing agency for ATIA card. It's an internationally accepted customs document which enables duty-free and tax-free temporary importation of items as commercial samples. The ATIA card reduces costs and red tape. The ICC is also known for its popular publications invaluable for bankers, lawyers, arbitrators and anyone involved in cross-border trade. Its members are provided with a member's privilege card which includes discounts with multiple retailers. ICC Sri Lanka's vision is to be the organization of choice to advance international trade and investment for businesses in Sri Lanka. ICC Sri Lanka's mission is to be the change agent in national policy formulation and implementation and facilitator of global businesses with Sri Lanka and disseminator of information on the development of business utilizing the services of ICC Paris while continuing to be a facilitator of dispute resolution. In addition, the ICC Sri Lanka organizes seminars, lectures, meetings with business leaders, and gives recognition to Sri Lankan businesses for outstanding achievements. ICC can play a special role in connecting business to the world and be a driving force for all Sri Lankan businesses.
Attorney at Law Mr. Shanil Fernando is the chairman of ICC Sri Lanka. Prior to his appointment, he served on the board of ICC Sri Lanka for 12 years and has been an active member for over 20 years. During his tenure in ICC Sri Lanka, he has chaired the Sustainable Development Financing, the ICC UN SCAP initiative, and the International Affairs Committee. He has also been appointed as a task force member of the ICC Commission on Arbitration and ADR. Mr. Fernando is a certified trainer on corporate governance and was trained by Commonwealth Association for Corporate Governance, London. He was awarded the Commonwealth Scholarship, which is now known as the Shivning Scholarship, to pursue his postgraduate studies at the Queen Mary College, the University of London. He has also studied at the University of Texas, Dallas, and was the recipient of the Achievers Award by the Postgraduate Institute of Management Professional Association of the University of Sri Jawatanapura. He is also a member of the Singapore Institute of Arbitrators and is a diploma holder in arbitration. In addition, he is a partner of the Anton Fernando Associates law firm. He is also the chairman of Asian Logistics Park Private Limited, World Express Private Limited, and AFA Corporate Services Private Limited. He is also a former independent nominated director of the Colombo Stock Exchange, Central Depository Systems Limited, National Wealth Corporation Limited, and was a former board member of the Urban Development Authority. And now I would like to invite Mr. Fernando to give the opening remarks. Thank you.
Good morning. Welcome to the third ICC Sri Lanka Arbitration Conference. I would like to welcome Honorable Justice Priyantha Jayawardena, Judge of the Supreme Court, Mr. Vikum D. Abru, President's Counsel, Additional Solicitor General, Ms. Viveka Sirivardena, President's Counsel, Additional Solicitor General, both nominated by the Attorney General's Department for this conference, and Mr. Sumati Dharmawardena, also from the Attorney General's Department. Dr. Harsha Cabral, he's on his way. He's also doing a presentation, and who was also the Sri Lankan nominee to the ICC Court of Arbitration, where he spent 6 years, 3 2-year terms. And we have Dinal Phillips, who is the present sitting member in the ICC Court of Arbitration, Paris. We also have Chandanalina Patibedi, President's Counsel. Tejas Chauhan, our ICC Regional Director for Southeast Asia, is present here today. He flew in from Singapore. Dr. Jude Benny, Mr. Murali Pani, Anil Chandragot, eminent arbitration lawyers, all from Singapore, will be linking in. We also have Mr. Alex, eminent lawyer from Sarawak, Malaysia. Mr. Anand Madmuran, eminent lawyer from Gujarat, India, is present here as a panelist. We have Himali, Director Legal BOI, India, Director Legal Colombo Port City, all other panelist speakers, colleagues, ICC committee members, ICC board members, ladies and gentlemen. Thank you for taking your time in your busy schedule to be here today for this important arbitration conference. As we embark on this journey of alternate dispute resolution by the arbitration and mediation, the International Chamber of Commerce, commonly known as ICC, stands at the forefront of facilitating cross-border business and advocating for fair and inclusive trade practices. The ICC's primary mission is to promote international trade and investment. ICC sets global standards and best practices, ensuring a level playing field for business, irrespective of their size and location. ICC continuously strives to eliminate trade barriers, simplify regulation, creating an ecosystem for the facilitation and digitalization of business. ICC first published Incoterm rules in 1936 due to different countries having different trade practices to do international trade. So a set of 11 three-letter terms, commonly known as FOB, CIF, DDU, X-Works, etc., reflecting the business-to-business practices in contracts for the sale and purchase of goods locally and internationally, was coined by ICC, and actually every 10 years they look at these terms and review the terms. So from 13 terms it was reduced to 11 terms last 2020. For the banking system, the ICC has developed the UCP 500, UCP 600, DocDex, the passport for goods, the ATA Carnage certificate where you can take goods across boundaries from country to country duty-free. The international trade country of origin certificate is also issued by ICC. Also they have the trade now SME 360 for the development of SMEs, agriculture hub, are a few trademark ICC facilitated cross-border trade instruments. Beyond its core role in trade facilitation, ICC actively engages in matters concerning responsible business conduct, in anti-corruption, prevention of commercial crime in international trade, corporate social responsibility with sustainable development goals in mind. By championing ethical business practices, the ICC emphasizes the need for business to operate responsibly, considering the environment. The ICC Sri Lanka promotes the ICC Academy in Singapore, the training arm of the ICC, by giving discounted prices for online training. And many Sri Lankans have been following these courses online. ICC promotes the ease of doing business for the international trade by digitalization, is very significant to the world economies, as it is only a result in increased efficiency, but allows countries to participate in encouraging opportunities for foreign direct investment, FDI. Arbitration is an alternate dispute resolution method of conflicts resolution started by ICC. This year, the ICC Court of Arbitration is celebrating 100 years of the world's leading arbitral institution. This conference will offer a unique opportunity to find ground and reach an impartial resolution to promote the use of ADR in our businesses. At this conference, we have the privilege of listening to eminent speakers, international panelists that have come together to address issues on ADR. As we proceed, let us remember the importance of mutual respect, active listening, and the commitment to reach a fair and equitable outcome. In conclusion, I request each one of you to join hands with the International Chamber of Commerce, Sri Lanka. Please give your suggestions and forward the authorities by email your suggestions and comments. I wish each and every one of you a productive, fruitful conference. Thank you.
Thank you, sir. And now we have a special message via virtually from Mr. John W.H. Denton, who is the Secretary General of the ICC. He's a global business leader and international advisor on policy and a legal expert on international trade and investment. He's also a board member of the United Nations Global Compact and co-chair of the Financing Growth and Infrastructure Task Force for Argentina B20 in 2019, as well as a founding member of the Business 20, the Australia-China CEO Roundtable, and UNHCR in Australia. Mr. Denton also serves on the board of the leading global infrastructure group, IFM Investors, and is co-chair of the Trade and Investment Working Group for the G20 Japan.
Friends, thank you for the opportunity to join you, albeit virtually, at today's important event, the ICC Sri Lanka's Arbitration Conference 2023, and my very special thanks to ICC's chairman and to the ICC Secretary General, not only for the kind invitation to speak, but also for the incredible work that you and ICC Sri Lanka have been doing in support of the Sri Lankan business community. 2023 will go down in history as a milestone in the history of arbitration. After all, it was precisely 100 years ago that the ICC's founders, the Merchants of Peace, established the ICC Court of Arbitration, and what is now considered to be globally the gold standard for international arbitration. But it was also a groundbreaking initiative in support of the international rule of law, in support of cross-border commerce, and in support of peace among nations. The mission of and the need for the Court of Arbitration, developed by the ICC, remain as important as during the interwar period, and as important as when ICC Sri Lanka was established in 1958, some 65 years ago. After all, we are living in times when the purposes of both the court and the broader mission of the ICC are under increasing strain. We know that the international rule of law faced one of its gravest and greatest attacks in the form of Russia's illegal invasion of Ukraine last year. We know that there are problems and challenges for global trade from growing protectionist actions. We know and we've experienced an unprecedented pandemic and the extraordinary pressure placed on supply chains. And we can feel the increasing tensions between the world's major powers. And so peaceful relations between states, which we actually want, have not only been compromised in the most dramatic fashion through this war, but also through a slow deterioration of the world's economic institutions, which are appearing increasingly ineffective and simply not reflective of the world in which we live. The ICC wants to do something about that, and we're working on it. And arbitration, for example, as you well know, plays an important role in securing both peace and prosperity. Arbitration allows for the orderly resolution of international commercial and investor-state disputes. Businesses can more readily trade abroad and lower their risks. Justice can be served and the rule of law preserved through arbitration. So allow me to congratulate ICC Sri Lanka for convening such an august group of judges, arbitrators, lawyers, and policymakers at this critical time for the world. But also at a critical time for Sri Lanka, which we all know is facing such difficult economic conditions. At the International Chamber of Commerce, we are fully aware of how challenging the economic situation is for Sri Lankans over the past few years. So many jobs lost, so many people struggling to afford essentials like food and petrol, and so much uncertainty that has rocked business confidence. Let me assure you that the ICC, we are doing as much as we can to deal with the massive public debt crisis that not only grips you, but has made scores of countries extremely vulnerable. We are working hand in glove with the United Nations Secretary General and his team in developing practical solutions to minimize the chances that vulnerable nations like Sri Lanka may default on their debt, that they are also able to reduce their debt servicing obligations so that the money can be directed to essential services like healthcare rather than interest payments, that other vulnerable countries can restructure your debts in an orderly way, and that you can be better served by organizations like the IMF and World Bank, which must be improved to provide more money and better financing solutions to countries in need. More broadly, and let me conclude with this point, today's political and economic challenges are different to the environment in which those institutions and economic governance for the 21st century was actually formed back in the mid-20th century. We need to ensure reform to make things better, to make things fit for purpose for the context in which we're operating. We do not want to see continuing debt burdens on countries like Sri Lanka. We want to help achieve a better balance between the interests of the so-called global north and the global south. After all, the ICC is now constituted by almost 70% of entities that are part of the global south. We are truly inclusive, and we want to take that forward as well and come up with an inclusive way forward. Let me thank you for the opportunity to speak with you. Let me actually wish you the best to all speakers and participants, and hope that you will have a wonderful and productive conference. I'm confident you will, because it's read by and run by ICC Sri Lanka.
Ms. Claudia Salmon is the president of the International Chamber of Commerce International Court of Arbitration and is the first woman president of the ICC Court in its almost 100-year history. Ms. Salmon is also an independent arbitrator specializing in international investor-state and complex commercial disputes. And here is a special message from her, which is also a virtual message. Thank you.
Hello to all of you in Colombo. I'm very sorry not to be able to join you, but as you can see from the background, I'm home this week in upstate New York. But I'm so glad that Tejas Jakan, ICC's Regional Director for Arbitration and ADR, based in Singapore, is there with you. At the outset, I would like to acknowledge and express our gratitude to the Honorable Justice Priyana Jayawardena of the Supreme Court of Sri Lanka for being here and addressing us today. Thank you to ICC Sri Lanka, led by its chairman, Shanal Fernando, for organizing this very impressive event. And thank you to Dinal Phillips, the ICC court member from Sri Lanka, and Dr. Harsha Cabral, former member of the ICC court. Our gratitude also to the distinguished speakers from Sri Lanka and beyond who have taken the time to join the conference. This year, we are celebrating 100 years since the founding of the ICC International Court of Arbitration. So let me just take a moment to talk about what we do and why we do it. The ICC itself, the International Chamber of Commerce, was founded in the wake of World War I by a pioneering group of entrepreneurs who called themselves the Merchants of Peace. They wanted to promote peace and prosperity through cross-border trade. Resolving disputes wasn't originally their focus, but they quickly recognized the need to promote cross-border trade and a mechanism to resolve cross-border disputes. And that is why they founded the International Court of Arbitration in 1923. They wanted to ensure that when parties are engaged in cross-border business or have cross-border investment, they have access to justice. In other words, they have an avenue of recourse. Businesses trading across borders do not want to find themselves in the courts of their counterparties. That process is often too slow or considered to be hard to navigate or untrustworthy. Whether you are in-house counsel or advising clients as outside counsel, I understand that every day you are asked to manage and mitigate risk. In this shifting landscape, you need to figure out how to protect your clients' investments to ensure their businesses can operate even in challenging circumstances. We know that conflict in business is inevitable. Businesses are made up of individuals with different values, views, and styles. When their differences diverge, conflicts ensue, often resulting in a time-consuming and costly distraction to the business. To mitigate that risk, businesses, large and small, as well as states and state-owned enterprises, need an effective avenue of recourse. So they turn to international arbitration to resolve such conflicts. International arbitration offers an independent and neutral process, free from political dynamics and influences, to resolve disputes in an efficient and cost-effective manner. We have our headquarters in Paris, but we are truly global and local. Parties in ICC arbitrations came from almost 150 countries, and 25% of the parties came from Asia Pacific. ICC arbitrations are seated in 120 cities around the world. ICC arbitration doesn't just take place in Paris or New York. It also takes place in Colombo. Singapore is among the top 10 seats in ICC arbitration. ICC arbitration takes place in many languages, English, of course, but you can have an ICC arbitration in Sinhala and Tamil or any other languages the parties choose. Arbitrators come from almost 100 countries, including Sri Lanka, and 25% of ICC cases involve states or state-owned enterprises. So let me offer you 3 additional points to keep in mind. First, our expedited procedures ensure that parties get an award within 6 months. They were introduced in 2017, and since then, we have had more than 500 of these cases under the expedited rules. We know the process works. They are designed to reduce time and cost for lower value disputes, but parties are opting into the expedited procedures even for larger amounts in dispute. Second, we know that construction and energy companies trust ICC to resolve their disputes. Disputes within the construction sector generated the largest number of cases, and combined with the energy sector, account for almost 40% of ICC's caseload. But we know that companies across all sectors, life sciences, technology, finance, tourism, agriculture, and apparel, trust ICC. They trust ICC because they know that ICC is the only arbitral institution that is truly international, not tied to any one geography or subject to shifting political winds. They trust ICC because they know ICC understands their needs. And third, and most importantly, we also understand that when you have a problem, you need a solution, and that solution may not be arbitration. The best way to manage risk may be to try to reach an amicable solution. So we are trying to ensure that parties have all of the tools in their toolbox to resolve their disputes. This could be an arbitration, but it could also be mediation or other techniques to enable the parties to come to that amicable resolution. This is why the ICC Commission on Arbitration and ADR just released 2 new guides, one on effective conflict management and the other on facilitating settlement in international arbitration. This delivers on our pledge set out in the ICC Centenary Declaration, launched earlier this year, to drive thought leadership in dispute prevention and resolution through innovative services, best practices, and standards that meet the evolving needs of an ever wider range of businesses and markets. So I will close with this. We are not just focused on the past. I want to talk about the future as we are shaping the future dispute prevention and dispute resolution in the age of AI. We are listening to you, to your needs and concerns, to make sure you have access to our services and how the services themselves use the latest technology to improve your experience and meet your needs. I hope you have a wonderful day at ICC Sri Lanka Arbitration Conference. We are so glad to have you part of the ICC community.
Our first speaker for this morning, His Lordship President's Counsel Justice Priyantha Jayawardena, is a sitting judge of the Supreme Court of Sri Lanka, appointed in 2014, and is a judge of the Supreme Court of Fiji and has been serving concurrently as a judge in both Supreme Courts since 2017. In 2012, he was appointed as a President's Counsel and is also a member of the Council of Legal Education and is the chairman of the Committee to Review the Existing Insurance Laws of Sri Lanka. Justice Jayawardena received his primary and secondary education at Nalanda College, Colombo, before entering Sri Lanka Law College in 1985. Thereafter, he was called to the bar and enrolled as an attorney at law of the Supreme Court in 1988. While he was in private practice, he also worked as a research assistant to the late Justice Mark Fernando and the late Justice P. Ramanathan. Thereafter, he joined the Attorney General's Department to work in the Government Institutions Division in the year 1991. Later, he proceeded to the United Kingdom and obtained a master's degree in commercial law from the University of Aberdeen in the year 1993. He also passed the Qualified Lawyers Transfer Test conducted by the College of Law in the UK and was subsequently enrolled as a solicitor in England and Wales in 1996. Upon his return to the island, he joined the Attorney General's Department and served as a state counsel before reverting to the unofficial bar in the year 2000. While serving at the AG's department, he worked as a consultant to the Ministry of Food, Internal and International Trade and Commerce. During this time, he prepared the initial draft of the Consumer Protection Authority Act No. 9 of 2003. He also served as a member of the Advisory Commission on Intellectual Property Law in Sri Lanka and has been an examiner for the Council of Legal Education. While in private practice, Justice Jayawardena served as a member of the Advisory Commission to the Intellectual Property Office, the Securities and Exchange Commission of Sri Lanka, and the Core Group on Information Technology, which was instrumental in the drafting of the Electronic Transaction Act No. 19 of 2006. He also functioned as a director of the National Savings Bank and the Lanka Electricity Company. Further, he has also been a visiting lecturer to the University of Moratuwa. And now we warmly invite Justice Jayawardena to speak on the topic Enforcement's Setting Aside of Arbitration Awards.
The President of the ICC chapter at Sri Lanka, the staff of the ICC Center, President's Council, members of the legal fraternity, distinguished and my dear friends. It is an honor and a pleasure to be standing before you this morning and deliver a speech on the enforcement of arbitration awards in Sri Lanka. I will start by commending the organizing committee of this conference for the mammoth effort put in by them in bringing together this conference, and thanking them for having me as a speaker. Why do we talk about arbitration? Why not go to court and litigate? Those are the issues that we need to consider. Unlike in civil action, the Arbitration Act number 11 of 1995 provides a simple, flexible, speedy, and informal procedure to resolve disputes between the parties. First, I will briefly address the applicable law for arbitration in our country. Section 2 of the Arbitration Act states that all arbitration proceedings that commence in Sri Lanka after the appointed date are governed by the said Act. The arbitration proceedings commence when a party gives notice of arbitration agreement to the other party. Thereafter, one or more arbitrators are appointed by the parties to the arbitration agreement, depending on the arbitration clause. The parties can decide the procedure applicable to the process of arbitration. Once the arbitration proceedings are concluded, the arbitrators should deliver the arbitral award in writing, signed by the arbitrators of the arbitral tribunal. Further, copy of the arbitral the award should be served on the respondents, on the parties. Furthermore, an arbitral award is final and binding on the parties, subject to applications that may be made under Section 31 and 32 of the Arbitration Act, that is to enforcement and to set aside the awards. Now I will come to the enforcement of arbitral awards. In my presentation, I will share my experience as a judge and also as an arbitrator, where I functioned long time ago. In terms of Section 31, subsection 1 of the Arbitration Act, a party to an arbitration agreement pursuant to which an arbitration award is made within 1 year after the expiry of 14 days of making the award, apply to the High Court for the enforcement of the award. If an application is not filed within the stipulated time, the High Court has no jurisdiction to entertain such an application. I must say, actually, our Arbitration Act is based on the Swedish Arbitration Act, and I was fortunate to be trained by the Swedish people who drafted that when I was in the Attorney General's Department. Section 31(2) of the Arbitration Act states, an application to enforce the award shall be accompanied by the original of the award or duly certified copy of such award. The original arbitration agreement under which the award purposed to have been made, or a duly certified copy of such agreement. According to Section 31(2)(b) of the Arbitration Act, when filing an application to enforce an arbitration award, the party seeking to enforce the award is required to file the original arbitration agreement or a duly certified copy of such agreement on which arbitral award was made along with the said application. Moreover, Section 32 of the Arbitration Act sets out the procedure for making an application to the High Court for setting aside an arbitral award. In that, it states that such an application may be made within 60 days of the receipt of the award. Further, the said section sets out the grounds on which an arbitral award can be set aside. Actually, those are very limited grounds, not on facts. Furthermore, where the applications for enforcement of an arbitral award and also to set aside an arbitral award are filed in the High Court, Section 35 of the Arbitration Act requires to consolidate such application and to be taken together for inquiry. In this regard, it is important to note that it is mandatory to comply with the time frame stipulated in Section 31 and Section 32 of the Arbitration Act. Did you know that quite a few applications are rejected by courts for not filing them in court within the stipulated time period? Further, the Supreme Court held that if an application to set aside an arbitral award is not filed in court within the stipulated time, it is not possible to resist an enforcement application on the grounds stipulated in Section 32 of the Arbitration Act. The inquiry before the High Court, actually, unfortunately, most of these judgments we write, but no one takes notice of them. That's why it's getting... The inquiry before the High Court is restricted to the grounds set out in Section 31 and Section 32 of the Arbitration Act. Further, Section 40 of the Arbitration Act provides for a sui generis procedure applicable to such applications. However, prior to allowing an application for enforcement of arbitral award, the court is required to satisfy that there is no cause to refuse the recognition and enforcement of the award, and the application is in conformity with mandatory requirements set out in section 31(2) of the said Arbitration Act. That means it's not automatic. Further, a party who has been made a respondent, such an application is not Further, a party who has been made a respondent to such an application is not precluded from drawing the attention of court if the petitioner has not complied with the mandatory requirements stipulated in section 31(2), notwithstanding the fact that such a party has not filed an application to set aside the award in terms of section 32 of the Arbitration Act. In such circumstances, the court is required to take such matters into consideration when deciding the application for enforcement. That's why I said it's not automatic. Sometimes court can act ex mero moto and see whether it's in compliance with the required provisions. Now, what are the issues that are faced in enforcement of arbitration awards? I have identified a few issues that are frequently coming up in courts with regard to enforcement of applications. Because of the time constraints, I selected only very few. Is it possible to refer several disputes to arbitration based on one arbitration agreement? I know there are a lot of experts here, but these are common matters that are coming up before our courts. Section 50 of the Arbitration Act defines an arbitration agreement, an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship between whether contractual or not. Arbitration agreement means an agreement by parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. The phrase, these I am referring to our Arbitration Act, the phrase all or certain disputes which have arisen or which may arise between them in section 50 allows the parties to refer all or some of the disputes between them to arbitration. Further, the phrase which have arisen or which may arise between them allows the parties to refer the dispute for arbitration when and where they arise. However, I have observed that some raise this as an objection in the enforcement proceedings. These are real objections that they take up in courts, unfortunately. Does the Civil Procedure Code apply to enforcement of arbitral awards? There is no provision in the Arbitration Act to file an answer in an application for enforcement of arbitral awards. However, the respondents can file objections to an enforcement application. Similarly, there is no provision in the Civil Procedure Code to file application for setting aside arbitral awards as well as to enforce arbitral awards. Moreover, the proceedings for enforcement and setting aside awards is sui generis. This was intentionally included in the Arbitration Act to have a speedy disposal of such applications by court. Further, it is pertinent to note that at the time the Arbitration Act was enacted in Sri Lanka, the amendment was brought to the Civil Procedure Code to repeal the provisions applicable to arbitration. Hence, the Civil Procedure Code is applicable only in instances where the Arbitration Act has specifically referred to in the applications of the the applications of the provisions of the Civil Procedure Code. Is it necessary to file the complete contract between the parties in an application for the enforcement of arbitral award? No, it is not necessary to file the complete contract. In terms of Section 31(2)(b) of the Arbitration Act, a party is not required to file the complete contract or the agreement in which the arbitration clause is included in an application for the enforcement of an arbitral award. On the contrary, Section 31(2)(b) only requires a petitioner to file either the original arbitration agreement or a duly certified copy of such agreement. Section 3(1) of the Arbitration Act states, an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Furthermore, Section 12 of the Arbitration Act states, an arbitration agreement which forms part of another agreement shall be deemed to constitute a separate agreement when ruling upon the validity of that arbitration agreement for the purpose of determining the jurisdiction of the arbitral tribunal. Hence, the arbitration clause is an agreement or a contract is recognized as a separate contract, distinct and independent from the main contract. As you all know, even if the main contract is declared illegal or a nullity, the arbitration agreement survives. Further, Section 3(2) of the Act states that an arbitration agreement should be in writing. In terms of Section 3, subsection 2, it shall be deemed to be in writing if it contained in a document signed by the parties or in an exchange of letters, telexes, telegrams, or other means of telecommunication which provides a record of the agreement. Actually, when we drafted in 1995, most of this new technology was not there. Our Commercial High Court held some time ago, even emails can constitute an arbitration agreement. So that we have interpreted other means of telecommunication, we have given a broader interpretation to that, our courts. In such instances, all such documents exchanged between the parties should be filed to prove the existence of an arbitration agreement between them. Moreover, there can be circumstances where it is not possible to file the original arbitration agreement in court, including instances where there are multiple applications for enforcement of arbitral awards. Thus, the Arbitration Act has made provision to cater to such instances by including a provision to file a duly certified copy of the agreement which the application for the enforcement of arbitration awards are made. Now, what constitutes a duly certified copy of the arbitration agreement? A duly certified, because that discretion is with court to decide whether it's duly certified. A duly certified copy means a copy certified by a lawyer or by the arbitration center or by a recognized agent of the claimant acceptable to courts. These is all developed by our courts as our jurisprudence develops. Furthermore, Section 12 of the Arbitration Act shows that the sole purpose of the requirement to file the arbitration agreement along with an enforcement agreement is to ascertain whether the arbitral tribunal had the jurisdiction to make the award sought to be enforced by the High Court. The issues relating to filing of certified copies. The main issue is that I am now coming into the practical problems that we have encountered. The main issue is that arbitration centers do not follow a procedure acceptable to courts in maintaining their records. It starts with issuing notices. It starts with issuing notices to the parties and ends up with serving the arbitral award. The centers use a handwritten list to send notices by registered post. When such a list is filed in court to prove that the notice of arbitration proceedings was given to parties and the award was served on the respondent, only God knows whether the notices were actually dispatched or not. In this regard, why can't the arbitration centers take a typed list to the post office with the names and addresses of the recipients so that the courts can be satisfied that the letters were in fact dispatched? Another issue is that the documents are not certified in a way that the court can accept them. I dealt with that issue a while ago. I have also observed that the certified copies filed along with the applications for enforcement of arbitral awards and applications to set aside the arbitral awards do not contain proper proceedings. Once again, I believe that the arbitration should maintain proper records of proceedings and documentation in a more methodical manner and issue a complete set of copies, certified copy of the same at the end of arbitration proceedings if the parties request for a certified copy. It's impossible to understand what is filed in courts. They file here and there all sorts of things that they obtain during the proceedings. Not in order, not according to chronological order. So those are the reasons for delay. The whole purpose of the act is lost. In this regard, I must say that the documents filed along with such applications in courts are the documents that the parties obtain during the arbitration proceedings, and thus those are very difficult to read and understand by courts. This may result in rejecting the applications too. I strongly believe that arbitration centers can play a major role in assisting their clients and courts to dispose applications expeditiously. I wish to conclude by saying that the whole purpose of achieving a speedy resolution of disputes depending on the efficiency of the arbitration centers, the counsel who appear in court, and the justice system. Thus, before I part with you, may I suggest the arbitration center, the ICC Arbitration Center, to conduct few programs, at least few programs, to enlighten the persons who are involved in the dispute resolution process of the technical issues that adversely affect the arbitration process. Thank you very much.
Thank you, my lord, for those invaluable comments. Our next speaker, Mr. Vikum Diabru, President's Counsel, is an additional Solicitor General at the Attorney General's Department of Sri Lanka. He was conferred Silk as President's Counsel in the year 2021 and holds a Master of Laws degree from the International Maritime Law Institute in Malta and a Master of Law degrees from the University of Colombo. He counts over 28 years of experience in litigation as a counsel representing the government of Sri Lanka and has appeared in commercial arbitrations in Sri Lanka and abroad representing the government and other agencies. He has also represented Sri Lanka in several international forums. Today, we are privileged to have him here to address us on the topic of the applicability of arbitration agreements in relation to admiralty claims in Sri Lanka.
His Lordship Justice Priyantha Jayawardena, President's Counsel, Judge of the Supreme Court, Mr. Shanil Fernando, Attorney at Law, Chairman, ICC Sri Lanka, and his team, distinguished invitees, ladies and gentlemen. I am honored and privileged to stand before this distinguished gathering to speak a few words on the topic applicability of arbitration agreements in relation to admiralty claims in Sri Lanka. I feel this is a timely topic to bring to your consideration on a day like today. Maritime trade generates a considerable amount of foreign revenue to Sri Lanka. The seaport of Sri Lanka handle over 7 million TEUs, that is 20-foot equivalent units, a year. Over 3,600 ship arrivals were recorded in 2021 to the main seaport in Sri Lanka, the port of Colombo. With the increased number of ship arrivals, it is inevitable that disputes related to financing, cargo, freight, crew wages, etc. would also increase. These shipping disputes are mainly resolved either by litigation before the court of law, that means the Admiralty Court, or by way of arbitration proceedings. So therefore, it is imperative to have the necessary legal infrastructure to resolve disputes efficiently. Such a legal system would undoubtedly help Sri Lanka with reaching her goal of being the main shipping hub port in Southeast Asia. My focus today is only in respect of this limited area of law mentioned earlier. May I be permitted to address first on admiralty jurisdiction in general. As you all know, ships are inherently mobile and travel from one jurisdiction to another. Unlike other mode of transportation, a ship is considered as a juristic person, a legal person. Accordingly, all claims in connection with the ship can be recovered from the ship. Such actions are described as in rem actions. The said mode of action is further to the traditional method of making claims against the owner of the ship. These actions are called in personam action. When compared to rem actions, personam actions are considered to be a difficult process, and therefore the rem actions are common all over the world. I would like to highlight that in order to assume jurisdiction by the Court of Coastal State in admiralty claim, it is sufficient that the ship is within the jurisdiction of the relevant court and the claim falls within the categories of maritime claims of that jurisdiction. That is sufficient to assume jurisdiction by the coastal state. The first uniform set of laws on arrest of ships was adopted in 1952. It was revised in 1990 with the introduction of the 1999 Arrest Convention. Sri Lanka is neither a party to the 1952 nor the 1999 Convention on Arrest of Ships. The Sri Lankan law on admiralty matters is identical to the Senior Courts Act 1981 in the United Kingdom. The jurisdiction of the Admiralty Court to hear and determine claims is limited to the claims set out in Section 2 of the Admiralty Act, and privilege claims, which we call maritime liens, I think most of you have heard of that, are described in the Merchant Shipping Act. With this brief introduction, I wish to remind you the issue I am focusing on again. That is, does the Sri Lankan law permit the arrest of a ship only for the purpose of security, for arbitral or judicial proceedings within or outside Sri Lanka? It is important to highlight the related contemporary domestic legislation in some of the major shipping jurisdictions before I focus on the Sri Lankan law. The United Kingdom. The position of ship arrest for security under the English law prior to the enactment of Civil Jurisdiction and Judgment Act of 1982 was that jurisdiction of the Admiralty Court would not be exercised to arrest a ship in an action in rem for the purpose of providing security for an award in arbitration. However, after the introduction of Section 26 of the Civil Jurisdiction and Judgment Act 1982, a party to an arbitration proceedings could apply to the court for the arrest of a ship in order to obtain security for the arbitration. This position has been affirmed by Shin J in the case of Jalamasta, that is reported in 1987, 2 Lloyd's report, page 64. What is the legal position in Australia? The Australian law is similar to the United Kingdom, the UK system. Section 29 of the Admiralty Act 1988 of Australia provides for ship arrest in order to obtain security to satisfy an arbitral award. In the case of Amanda N., reported in 1989, 21 FCR 60, where Shepard J stated that such arrest could be made for both pending and future arbitration. What is the position in Singapore? There are no statutory provisions for arrest of ships in Singapore for the purpose of obtaining security for foreign court proceedings. This position was affirmed by DSA Consultancy versus the Eurohope 2017 5SLR, reported in 5SLR, page 934. However, I wish to note that a ship arrest as security for arbitration are permitted under Section 7 of the International Arbitration Act of Singapore. So what is the position in India? Indian law does not have explicit provisions for arrest of ships as security for arbitration. India is not a party to both 1952 and 1999 arrest conventions. However, in the case of Embassy Success 1, the court held that 1999 arrest convention can be applied as a provision of law in India, since there is no express prohibition to apply the 1999 arrest convention. The court has proceeded on the premise that the power vested with the court is unlimited unless there is an express provision that restricts the power of the court. The Sri Lankan law position. The jurisdiction to hear and determine matters was raised in Sri Lanka. I believe that was for the first time in the case of motor vessel Theropyle Sierra. In this case, there was an arbitration clause in the bill of lading issued under charter party contract. The High Court delivered the order refusing the objections to the jurisdiction to hear the case raised on behalf of the ship owner. Against this order, there was an appeal to the Court of Appeal. The Court of Appeal held that since the charter party arbitration clause was incorporated in the bills of lading, any party claiming rights under the bill of lading would be bound by the provisions of charter party and thereby agreed to resolve dispute by resorting to arbitration. The Court of Appeal accordingly decided to recall the writ of summons in rem on the basis that plaintiff's admiralty claim is bound by the arbitration clause to resolve the dispute by resorting to arbitration. So that is one case. But a few years later, the same issue was raised in the case of SCI Mumbai, reported in CAPHC 47 of 2007, 30, that's not that relevant. In this case, Court of Appeal ventured into the sole question of jurisdiction under the Admiralty law in the light of arbitration clause. The court observed that the Admiralty jurisdiction of the High Court to decide claims or a question set out therein is a special law and applies over the Arbitration Act. The court position was that Admiralty law is a special law and that applies over the Arbitration Act number 11 of 1995. The Court of Appeal, having considered the Arbitration Act and the wording contained in Section 2 of the Admiralty Act of 1983, which has a clause to say that notwithstanding anything contained in any other law, held that in spite of the arbitration clauses in Admiralty, in maritime claims, the Admiralty High Court has jurisdiction to hear and determine any matter. So the first case, the court held that if there is an arbitration clause, then the court will not assume jurisdiction, but in the second case, court held that court would assume jurisdiction to hear the case in spite of the arbitration clause. In summary, in other jurisdictions mentioned above, as mentioned about India, Singapore, UK, Australia, there are provisions in the Arbitration Act or in the Admiralty law or in some other legislation or sometimes by judicial pronouncement like in India, permits the arrest of ships as security for arbitration proceedings in respect of maritime claims. As held in Professor Priyani D'Souza versus Arsukularatna, reported in 2001 2SL page 293, in Sri Lanka, the judges are not entitled to change the law. Not entitled to change the law. The structural changes to the law should be done by the legislature. Therefore, necessary legislations to reflect the development of the law should be introduced very early to make Sri Lanka as an attractive venue for ship arrest. So I recall in 1980s, there were over 80 ship arrests, over 80 to 100 ship arrests in Sri Lanka. Now it has come down to 6 ship arrests a year due to number of reasons. Thank you very much once again for extending an invitation to the Attorney General's Department to take part in this symposium to discuss matters that are relevant for consideration. I thank the distinguished guests for your patience here. Thank you.
Thank you, sir, for those insights. And now we have our first international speaker for today, Mr. Tejas Chauhan, who is the Regional Director for South Asia and is responsible for structuring and implementing ICC strategy, overseeing operations and promotion of ICC dispute resolution services in 20 countries covering Southeast Asia and the Pacific. He focuses on assisting companies, councils and investors to understand how they can resolve commercial disputes by raising their awareness about ICC dispute resolution services and advising on ICC arbitration proceeding protocol. Before joining ICC in Singapore as the regional director, Mr. Chauhan also worked with the ICC in India and with the forensic and dispute advisory services at a Big Four audit firm. Today, he is here to speak to us on the overview of ICC arbitration and ADR services. Please join me in warmly welcoming Mr. Chauhan to the stage.
Thank you so much, ladies and gentlemen. Justice Priyanka Jayawardene, members of the Attorney General's Office, distinguished guests, ladies and gentlemen. It is always difficult to speak after a break and in the company of such distinguished speakers. So I have the difficult job of getting your attention and seeking your indulgence for the next 10-15 minutes. Now, you've heard from my Secretary General, John Denton, and you've also heard from my President, Claudia Salomon. So there is little that I have left to offer now, but I will try. Now, Sri Lanka is the last leg of my travel. I've been traveling continuously for the last 10 weeks. I've traveled to 8 countries. So I look forward to being back in Singapore. But over the course of the last 8 weeks and in flights, I've met a lot of people, lawyers, in-house counsels, government representatives, actors, distant relatives of my own family on flights, which was just an absolute coincidence. But something that I was really looking forward to was Sri Lanka. And it was not just for the egg hoppers or the appam, but actually given the long-standing relationship that India and Sri Lanka share, which is where I'm from, which is where I was raised, and the potential for growth that is in Sri Lanka. Now, of course, I will wear the ICC hat and I would like to speak to you about the ICC, but if we keep ICC aside for a moment, all of you are lawyers, all of you are perhaps going to be involved with drafting contracts, negotiating contracts, and while you're doing so, for your organizations, for the government, for the state-owned entities that you represent, there will be a dispute resolution clause. So you're focusing on the rights, you're focusing on the warranties, you're focusing on the representations, but there is also a dispute resolution clause, which is more often than not copied and pasted. Now, I've been a corporate lawyer myself, and it was a standard template, right? It would come late in the night, and you would copy that clause, which would say all disputes arising out of this contract will either go to London, Paris, Geneva, Singapore. We'll have 3 arbitrators, irrespective of the amount, irrespective of whether it could be a sole arbitrator or 3 arbitrators. Many a times you would subscribe to governing laws of countries that you might not be familiar with because you've not paid attention to the dispute resolution clause. So first and foremost, I would start by saying that is an important clause. So when you've covered everything, please also look at that, because there are options available there. Number one, whether you would like to subscribe to court litigation. If not court litigation, whether arbitration or mediation. If it's arbitration, whether it's domestic ad hoc arbitration, or whether it's institutional arbitration under the rules of ICC or any other institution that you may prefer, right? But since you're all at an ICC arbitration conference, I would presume and move with the understanding that you're interested in knowing more about the ICC, so I would seek your indulgence there. Now, why ICC and why would you choose ICC? First and foremost, it is the International Chamber of Commerce. It is not a center which is linked to a country. So it is neutral, it is international. Many governments and many state-owned entities perceive the ICC to be international that way. You can have an ICC arbitration in Sri Lanka, you can have it in Colombo, you can have it in Singapore, you can have it in London, Paris, wherever you want. The rules of the ICC do not prescribe that you must have your arbitration in Australia, Singapore, wherever. In fact, it becomes more expensive if you have a dispute where the seat of arbitration is not Sri Lanka and the arbitration is taking place in a country which is not Sri Lanka, because then you will be moving with your legal teams, with your in-house counsels, yourself, and going to countries which will make the entire process very expensive. Being international, the ICC is also not linked to shifting political winds. So it is not that the government of a country will fall and the ICC will also fall. It is also not privately owned, so there will never be a dispute internally, and there will be never hopefully be two ICCs, right? As we've seen with other arbitration centers in countries. Now, second, a very important factor is the scrutiny process of the ICC, and something that we truly consider the USP of the ICC arbitration process. Because in the end, when you are subscribing to arbitration, you want a good enforceable award. You want an award that you can go to the courts with, get it enforced, and you get the recourse that you were looking for. This is possible because you have institutional oversight under the ICC rules. No institution does the scrutiny like the ICC does. If you were to just Google right now, ICC scrutiny process, there is tons of literature available online on how the ICC does scrutiny. And I will spend some time explaining this process. When I say scrutiny, I do not mean that the ICC is interfering with the arbitral tribunal's discretion to come to a decision. So if the tribunal is held that company A should be held liable to pay damages to company B, the ICC will not step in and say, sorry, you got it wrong, it should be company B. That is not the job of the ICC. But the ICC will step in and say that you've got your calculation wrong, or you might want to provide more reasoning, or this is against the public policy of Sri Lanka and this would perhaps not be enforceable in Sri Lanka, or this is a ground for setting aside. And we see that very often. And how this happens is, the first level scrutiny is done by the case management team, which would be in charge of your case. So it could be a team in Singapore, it could be a team in Hong Kong in Asia, it could be a team in Paris, it could be a team in New York, Abu Dhabi, Sao Paulo, depending on the seat of arbitration, depending on the governing law, depending on the nationality of the parties. The council in charge will prepare what is called an agenda and say that these are the comments on the award and this is perhaps something that needs more attention. It will then be submitted to the management of the ICC, which is the Secretariat, which is the Secretary General, the Managing Counsel, or the Deputy Secretary General. It will then leave the ICC Secretariat, of which we are all a part. It will now go to an independent court, which is called the ICC International Court of Arbitration. So while the name of the ICC is the International Court, it is not a court per se. It is an independent body comprising of 195 members, court members from across the world. And we have Mr. Donald Phillips and Dr. Harsha Cabral, who served on the court and continue to serve on the court. And they will testify to this. The court members are arbitration experts or represent countries where we need inputs from them on the local laws or perhaps enforcement issues, right? They question the ICC on why have you fixed the fees of the arbitrator at so-and-so amount. It should be higher, it should be lower. Or why is the ICC doing this? They decide on jurisdictional issues. They decide on challenges, etc. What this process is doing is, this process is providing you an independent body. And this is a process that works. To give you statistics on this, in 2021, the ICC notified 630 awards. This is more than any other international arbitral institution. Out of those 630 awards, 621 awards were approved with comments. That is that the ICC has these comments, and while the award is okay, you might want to consider this and you might want to change so-and-so in your award, perhaps provide more reasoning, or the calculation is wrong, or something with respect to just proofreading issues. Only 9 awards out of those 630 awards were approved without any comments. So the scrutiny process is so stringent that I was talking to an Australian renowned arbitrator, and she said one of the life's ambitions is to have an ICC award without any comments. And there were 69 awards which were not approved at all. And this is an important number because consider yourself as in-house counsels. What would have happened if you did not have the ICC and you were one of the parties to those 69 awards? Those awards would have not been enforced. So you would have gone back to the same process. Again, you would have gone to the courts to set aside an award. And it would have resulted in, of course, more time and more cost. So this is where parties trust ICC, and that is why perhaps they subscribe to ICC, because the court is something which is unparalleled. And if I had to give you another one, I would say transparency and accountability. This is important because just as you're choosing your lawyers, just as you're choosing your law firms, you're also choosing an arbitration institution to provide a service. Because in the end, all arbitral institutions are doing is to provide you a service. There's no rocket science behind what arbitral institutions are doing. The work is done by the tribunal. And just as you're paying your lawyers, or just as the lawyers are being paid, you expect a certain kind of service and accountability. So what happens if you had an ad hoc arbitration, but your arbitral tribunal is delayed because they decided to only sit after court hours at 3 o'clock or 4 o'clock or 5 o'clock, and the arbitration is stretched? Or what happens if they're charging fees which you do not think is reasonable? And that is where the institution comes in, because the fees will be capped, or the institution will make sure that the arbitration is on time. And how does it do so? Again, only the ICC does this, where if the arbitrator is delayed with the award or with the process, the ICC will sanction the arbitrator, reduce the fees of the arbitrator, and give it back to the parties. So the advance on cost that you paid initially to the ICC, a part of that will come back to you irrespective of whether you are winning the arbitration or losing the arbitration. But this has to be on account of an unreasonable delay. Now, when we launched this, there was a lot of hue and cry within the arbitration community about who's the ICC and why will they reduce our fees? They don't know what is going on, and there's so much work that the arbitrators have to do. So it's not just the arbitral tribunal or the arbitrators, the ICC itself. And ICC has this codified, where if the ICC is delayed, for example, with constituting your arbitral tribunal, or with the scrutiny of the arbitration award, you can write to the ICC and say that we expect a reduction in your fees because you did not perform your service. This has only happened in 0.006% of the cases in the last 5 years, where the ICC was unreasonably delayed. But this is a provision that you have, because in the end, that is what you're paying for. Now, finally, a comment that I often hear, and perhaps you would also have in your mind, is that ICC arbitration is expensive, and that's why we are choosing other institutions, or that is why we are going for other institutions. Let me start by saying that we do not perceive ourselves to be a cheap institution. I'm not going to say that ICC is a cheap institution and ICC is going to work out very cost-effective. Of course, there is a cost associated to it, but if you compare ICC with any other leading international arbitral institution, it would perhaps be the same. And for that, to give you a certainty, there is also a cost calculator of the ICC on the website of ICC. So when you're negotiating contracts and you see an amount in dispute or you see the amount in value, you could go to the ICC website, put the amount, select the number of arbitrators, and it will give you a minimum, average, and a maximum fees of the arbitrators and of the institution itself. So when you have an ICC arbitration, the ICC will fix the fees at average. Other institutions also have cost calculators, they fix the fees differently. So if you compare any other leading arbitral institution, you would perhaps know that, the costs are comparable, right? But if you were to compare it with a local arbitral institution in Sri Lanka, yes, ICC would be expensive. But let us not get into the cost bit, because cost is a result of service. Just as you're choosing your lawyers, just as you're choosing your law firms, and just as you have those big $1 billion or $1 million claims, you want to ensure that you have good accountability or a good institution, right? And that is where the ICC comes in. So I, of course, have done this research, and I have enough research on this to share costs. But there was a study, which is also in the ICC Commission report on controlling time and costs, where we analyzed about 321 arbitrations. out of those 321 arbitrations, the idea was to analyze what is the cost that parties are spending in an arbitration. Perhaps not as a surprise, but the result of that was that of every $100 that is being spent in an arbitration, $82 is going to the lawyers as legal fees. $16 is the fees of the arbitrators, which will always be capped. And $2 is the fees of the institution. So this whole argument about this institution is expensive and this one is cheaper is within the $2, right? I've been a lawyer myself and I've billed tons and tons, but this is a fact. Because the fees of the lawyer starts from the initial filing till the enforcement stage. And keep in mind that this will, of course, increase depending on the law firm that you go to and depending on the country that you have your arbitration in. But again, these are considerations of cost. Because the fees of an institution, and all institutions have a fee scale, will always be capped and will always tell you that this is the maximum they can charge. Now, as I conclude, ladies and gentlemen, I would just like to say that the idea here was to bust some myths about ICC and introduce it. This is, of course, something that cannot just be done in 10 minutes or 15 minutes. This is my first trip to Colombo, but I have told myself and I've ensured Shanil also that I will keep coming back. So if there's any information that you need on the ICC, or you need me to talk to you, your clients, tell you more about the ICC, I would be happy to do this. I would also pick on Justice Jayawarden's comment on training and capacity building, something which is at the core of the ICC and something that is also part of our centenary declaration. We're doing this across regions, with governments, with the judiciary, where we want to train and we want to have capacity building programs. And that is not going to be about the ICC, that is going to be fundamentals of arbitration, because in the end, all of us need to be trained to enter into a negotiation or an arbitration where we have the knowledge. And that is something that we're very happy to work with. If you have any ideas, please do let me know. I look forward to exchanging ideas. I thank you once again for your time and for your indulgence. And I look forward to discussing more with you. I'm also grateful to Mr. Shanil Fernando and the team at ICC Sri Lanka for organizing this impressive event and having us here. Thank you, ladies and gentlemen.
And that was just a little insight into the work that ICC does in Sri Lanka and around the world. And also thank you to Mr. Tejas for that very insightful speech. We have next joining us virtually from Singapore, Mr. Dato Jude Benny, who is the founding partner of Joseph Tan Jude Benny LLP Singapore. He has 39 years of experience as an advocate and sits regularly and primarily as an international arbitrator for organizations such as ICC, LCIA, SIAC, and BANI. He has significant commercial exposure, having served as a director of the Maritime and Port Authority of Singapore, the Singapore Maritime Foundation, and on the board of internationally listed shipping companies like BW LPG. He led the working group that established the Singapore Chamber of Maritime Arbitration while serving as a director of the Singapore Maritime Foundation, rather. Today, he's joining us virtually from Singapore to speak on the topic Enforcement of Arbitration Awards, the Endgame.
A very good afternoon, or good morning, I should say. It's afternoon here, though. Ladies and gentlemen, I'm delighted to be able to speak with you, albeit for about 10 or 15 minutes. But I'm very grateful for the invitation. I've spoken in these conferences before. I apologize for not being there personally. I would have liked to have been there, but I've got travel commitments tonight, so I'm very sorry about that. When my very good friend Chairman Shanil Fernando asked me to speak, I was thinking what could I speak about that would be sort of one size that fits all. I know that we've got very distinguished, eminent legal luminaries in the audience, but they're also, I'm sure, students. They're also commercial people. So I tried to pick a topic which would be sort of a one size that would fit all. The topic that I've chosen is enforcement of arbitration awards, the end game. And I think the end game is very, very important and something which many people tend to overlook when they're entering into an arbitration. So let's try and put this in perspective. Firstly, when you get into an arbitration, it's the result of a contractual clause, as Tejas pointed out. Many people disregard it, don't look at it because they're so concerned about how much money they're going to make under the contract that they don't really bother about this little clause that's right at the end. But what that clause does to you is that it pins you down to a particular jurisdiction. So where is that? I've had many parties come to me, and what I'm sharing with you is the result of years of experience, things that have happened over the years. I've had parties come to me and say, "Oh, I've got this problem. Look at the contract. They've got an arbitration clause that provides, say, for London jurisdiction. Not unusual, but where are the parties? One is in Indonesia, the other one's in Singapore. So why have you chosen London arbitration? Did you even read this clause?" Many of them are looking at it for the first time. But now, then they will ask me, can we get the other side to agree to change this? So I say, hang on for a minute. You want to commence an action and basically sue the other side, and you want him to agree to make it easier for you to do that. What do you think are the chances of that? So I said, he's not going to agree. So you're stuck with this. So now, you've got to look for your evidence, which is probably all regionally based in Asia. Look for your witnesses, and what are you going to do? You're going to take it to London for a hearing there? Well, I've got no objection to going to London for a shopping spree, but it's all of this is going to be on the account of the parties. So picking your jurisdiction is important. So the venue where the game is going to be played, and I use that word game because I'm going to use football analogies in this talk, is important. So now you commence the arbitration, you get into it. Let's say it's a large claim, and you could end up spending a few $100,000 pounds or US dollars, with counsel, with solicitors, barristers, and everything, to get your award. Now, many people, once they get the award, fantastic, they've won. And then I say to them that at this point in time, all you can do with this award really is find a really good frame maker. You can frame it up and you can hang it on the wall, because you can do nothing with this award. Because this award, unless you have such an honorable respondent, and that's a very rare breed, I can tell you. If you have an honorable respondent where you've succeeded, or a counterclaim succeeds, and you want to go after the claimant to pay it, very few people are going to pay because you send a letter of demand with a copy of the award and say, look, I've won, I've got an award for, $6 million US dollars plus cost of another 500,000, pay up. I can tell you, nobody's going to pay up. They want you to come after them. So now we get into the end game, because all you did up to now was only halftime. You're only leading at halftime. So it doesn't matter. We've now come to the final whistle is about to blow now. So you've got a situation where you have to enforce this award. What does that mean? Basically, you go back now to the jurisdiction of the party that you need to go after. You know, when Myanmar was opening up, we had many contracts where they used to write in SIAC, Singapore Arbitration, because the parties, were all so excited about doing business in Myanmar. Contracts all wrote Singapore Arbitration. Then things started going wrong. Now, when things start going wrong, they commence an arbitration, they get the award. International party gets the award, oil company or whatever, they get the award against Myanmar party. What are you going to do now? End game is about to begin. You now have to go to Myanmar. You have to get into the court system of Myanmar to enforce this award. You got to convert it into a judgment. Otherwise, it's nothing. So you now have to engage the local system. Have you ever tried to sue in Myanmar? It's not going to be a pleasant experience, right? Myanmar is just one of many countries where you would have a great difficulty trying to engage the local system in order to convert this into an award. Now, some countries are arbitration friendly. Singapore is an arbitration friendly jurisdiction. You get an award, you can probably have it converted into a judgment in about 6 weeks. I have had awards, for example, trying to convert it into a judgment in Indonesia. 6 years later, I'm still trying, because lo and behold, at the date of the first hearing, the file mysteriously disappears. They say, no, we don't know where it is. Next hearing, you somehow reinstate the file a new thing and whatever. Next hearing, judge is sick. Postpone. So how the system works, in different jurisdictions is something that you have to factor in at the time you're committing to a jurisdiction. We all know that, under the New York Convention, if you get an award from a New York Convention state, you can enforce it in another New York Convention state. So great. So one of the things that you really need to do at the time you're getting into the contract is not just to look at the jurisdiction where this hearing is going to take place, but you also need to look at where you would have to go. In other words, what is the domicile of the potential respondent or claimant that you're going to have to go after? Because you are going to have to enter into that jurisdiction, engage them on their home ground. And I've had so many instances, and sometimes I don't like to mention which country because it does upset some people. But you can probably all go and guess anyway, where they will say, don't bother, let them get their award. The respondent will say, don't even engage. Plus, claimant not only will have to pay his share of the deposit, he'll also have to pay our share of the deposit. Let him do it. Let him spend his money. Let him get his award. Then when he comes to our country, that's when we'll deal with this guy. This is like a mafia game, So let them come, because they know either they can buy the judiciary, or they can buy the lawyers, or they know how to play the system, that it's just going to be bogged down for years. So you need to know this before you get into the game. Where is this end game, this extra time? You may have won in full time, but we are going into extra time now. What's going to happen in extra time? That's what you need to be thinking about. So the entire process may have been futile. You could have spent hundreds of thousands because you did not take into account how the end game gets played out and where it's going to get played out. So if it's going to be one where you are potentially going to have these issues, then you may want to think about trying to negotiate a settlement or whatever, because conceivably could have a situation where you've thrown good money against bad, and the net result is a loss for you, right? You've thrown good money, getting the award in London, now trying to go and get it enforced, only to find that the local judicial system is one that is going to raise a lot of hurdles for you to try and bring that to fruition. So one of the sort of questions that I always ask foreign lawyers when I have to look into this is I ask them if it's an award that is by default. In other words, it was not on the merits because the respondent didn't engage. So you get an award that's not on the merits, and you bring it back to the jurisdiction where you want to enforce. And I can tell you, there are quite a few jurisdictions where the lawyers have told me if it's an award that's obtained by default, then there's a high probability that the local court will probably not permit or endorse the conversion of that award into a judgment, because you'll get a hue and cry. I have had a situation equally where the respondent says, but judge, you know why I didn't participate? Because the ICC asked me to put up 200,000 as my share. Tejas, I'm just joking, but the amount can be true, or SIAC or whoever. And they say, but we are a local company. Where am I going to find this money? I couldn't. And so they just steamrolled all over me. I never had a chance to speak my piece. We couldn't participate. And that's how they got this award. And so now they're trying to come here and enforce it. Please help me, judge. What kind of judge do you have? I don't know. Some are sympathetic, some are nationalistic. Oh, we must protect our poor little company here. So we are not going to. In other words, worse still, they'll say you have to go and start again. So but for the claimant, where is he? He's nowhere. And then of course there's the other thing. How long does an arbitration take? Let's say maybe a year. Complex pleadings and things like that, statement of saying and hearing, and then the arbitrator takes another 3-4 months to write the award or whatever. 3-4 months is quite fast, by the way. Anyway, you know what's happening in the meanwhile? I'll tell you what's happening. Respondent is disposing all of his assets. All gone. So you come, you get your award, and let's say you actually convert it into a judgment. And now enforce against what? How about a great big zero? Because there's no more assets. The guy is not stupid. He's not going to sit there and wait with all of his gold for you to come and take it. So you have a situation now. You convert your judgment, and then what do you have to do? Wind up the company. And you know what respondent will say? Thank you very much, because I would have had to pay the winding up fees myself. Now you please do for me. Because in the meanwhile, his lifestyle hasn't changed, because he and his brother-in-law have started another company doing the very same thing. And what are you going to do? You're going to sue them, lift the corporate veil, start a new action. Where is all of this going? So my point here, really, in 15 minutes, is simply to tell you, if you don't think about where the end game, or what the end game is, or what your strategy is to overcome the potential problems that can arise when you try to meet these issues, then you could find yourself caught between a rock and a hard place. And it's not pleasant, because you would have found the entire exercise one in futility. I wouldn't want that to happen to my clients or to happen to any one of you. So, if you're advising, so my advice really is to have the entire analysis done before you even spend $1. Or well, maybe you might have to spend some dollars. talking to a lawyer to analyze this whole thing for you and to see what steps you possibly need to take, the searches you need to do, the checks you need to do to ascertain the potential problems and difficulties that you could have if you have to enforce the award down the road. So, ladies and gentlemen, with that, I know I've sort of hit about 15 minutes now. So, thank you very much, all of you, for indulging me and listening to my ranting, which is what I enjoy doing now and then anyway. So, thank you very much, and please have a very, very good conference and day ahead of you. I wish I could. I see that there's some lunch later. I wish I could join you, but unfortunately, I'm here in rainy Singapore. It's raining a lot here today. So thank you very much, and please enjoy the rest of your conference.
Thank you, sir, for that engaging discussion. We actually have a question from our online audiences for Mr. Dato. This is with regard to training. Training is something that has come up from the inception of this event, the training required for the centers, for arbitrators, for the professionals and lawyers involved. What do you think Sri Lanka requires, or what are the steps that we can take in order to make this happen, or to really transition into what we need for training in Sri Lanka?
Yeah, thank you for that question. Over the years, I've been involved a lot in both setting up arbitration centers. I was involved in Singapore, in Dubai as well, and it's not even before we talk about training. The most important thing that you need is a vibrant arbitration landscape. So that is your first challenge. Because a vibrant arbitration landscape will then stir the necessary interest for people to participate and for people to be trained as and to have the opportunity and the chance to be able to sit as observers with the permission of parties, of course, with a senior arbitrator. So I think training can be split into two things. One is the academic training, and the other is the practical training. For the academic training, that's very simple because and I know even in Sri Lanka you run various courses to obtain the necessary qualifications. But I think more important than that is to have the opportunity to have a dialogue with senior practitioners who will be able to impart. You see, the things that I've told you today, I'm sure you can find in the books, but you're going to find it in 5 different books, and you've got to put it all together. But what you would want is for young arbitrators, potential arbitrators, to have the opportunity to engage with senior arbitrators in sort of meetings and dialogue sessions where all their queries and questions, and they would have many questions because they don't have the experience. And senior practitioners can then share this experience. So academically, of course, that's a given. You have to be able to get the qualifications. But the ability to engage and the ability to participate in as observers and sit with senior arbitrators through a hearing, I think that is vital. But you need to have a structured landscape and a structured course, which should be run, I think, every year at the entry level and at an intermediate level for people who want to be arbitrators, and actually even for practitioners who don't want to particularly be arbitrators, to participate in these courses. It will improve their base of knowledge insofar as arbitration procedure is concerned. So yes, formal training, and you should have it structured so that people know this is not a one-off thing. Sri Lanka is not addressing these courses as a one-off thing just because it's the flavor of the month. It's something that is run every year. I know if I can't do it this year, I can do it next year. They participate in this, but for purposes of the academic training. And you should have a, possibly if you can do a structured internship type program to allow interested parties to actually engage with and or observe senior arbitrators, that would help a lot.
Right. Thank you so much, sir, for those very practical points. I'm sure our audience has really benefited from it, and it'll be a key takeaway from today. Thank you.
My pleasure.
And on that note, we move on to the next speaker, Mr. Dinal Phillips, President's Counselor, who has over 40 years of experience in civil litigation, particularly in commercial laws, the commercial law areas rather, of admiralty, arbitration, and intellectual property. He also specializes in areas related to sports law and entertainment law. At present, he is a member of the ICC International Court of Arbitration and is a panel arbitrator at the Sri Lanka National Arbitration Centre. He is also the founder member of the Austrian Association of Sri Lanka and is a member of the Intellectual Property Committee of the Ministry of Justice. He was also a one-time chair of the Intellectual Property Advisory Commission and is here today to speak to us on jurisdiction of an arbitration tribunal.
Thank you for those kind words. Yes, following Tejas and Jude Benny is a hard act to follow, but nevertheless I'll try to compensate. But before that, I would like to thank a few people. His Lordship, Justice Priyantha Jayawardena, for taking his time off. I know the Supreme Court is working 2 sessions every day. For you to come and be with us for such a long time is a privilege, sir. And those of you who do not know Justice Jayawardena, we knew him when he was a practitioner at the unofficial bar. Then he went across to the Aegis department. He was also an arbitrator for a short while. So he brings in a wealth of experience to the Supreme Court. And it's quite easy when you're presenting a case before him. He knows what it's about, so you can't bowl your googlies on doosras there with him. Then Claudia Solomon, our chair. Thank you very much, Claudia. I know she's not here, Tejas is here. More about Tejas later. But she's, I know, got her hands full with the annual sessions coming up in Paris soon. And she's really working around the clock and made some huge changes to the way ICC functions, which is for the betterment. And of course, my friend Tejas, is the first time I met him. He's so busy traveling, the wife says she'd rather meet him at the Shanghai airport to discuss household issues rather than waiting till he comes home. And Anand here, thank you very much, sir, for coming from your busy schedule in India. And it's a working day for you there, so it's a big sacrifice for you to be here for this whole day. Right. So much for my thanks. And with the limited time available for me, I will try to not remain so sexist, but it's try to make it like the lady's skirt. Short enough to be interesting, but long enough to cover the important bits. So, anyway, why arbitration? We have judges, experienced judges, wonderful courthouses. So why go for an arbitration? 2 points, there are several, but 2 important points is, one is quite often arbitrations are sought of today by business houses. I'm not referring to the olden day, which when arbitration first started with the Act. I think every lending institution put an arbitration clause in their hire purchase agreement and their lease agreement. And that caused more problems than solutions. And hence arbitration became a bad word. But for a business house, it's important because time is money for the businessman. Let me tell you an example I had. Several years ago, there was an admiralty dispute, and the respondents or the defendants came up with 75% of our claim. Now, the young managing director, who had just come from Harvard Business School, I think, was trying to impress his father that he went the whole hog, wanted to get 100% of the claim. And they said, okay, catch me if you can. So after about 3 postponements, the father decided to come and meet us. And he asked the senior counsel, what's this? How much is the claim? How much are they offering? How much time have you taken? Right, sir, take it. So the son said, but Pop, Thambi, you just keep quiet. You're wasting far more time in courts, paying the lawyers, and let's get on with the thing. So that speed is of essence for business houses to get through. So that's why we go for arbitration. The other point is, it's a specialist job. You see, the poor judge sitting there sometimes deals with utterly complex issues. For instance, a ship is going down in the high seas. Distress signals are sent out. And there comes the salvos. SOC sent out, salvos come in, they sign the Lloyd's no cure, no pay form, and everybody is saved, cargo is saved, everybody is happy. Then he puts in his bill. Too much. Now you have forgotten that you are begging to be saved. And then comes, he says, no, there was a tempest, the storm was on. They said, no, there's only a little bit of rain there, etc. So that has to be decided upon. Now, the poor judge sitting there is all at sea, so to speak, on a dispute of this nature. So it's far better, this is heard between where a panel where experts come in. You have a master mariner, you may have a diver, who adds practical value to perhaps the legal entity who's sitting in as the umpire or the chairman of the panel. So that's a very useful factor. That's why people go in for arbitration, because of the specialist factor. There's another arbitration which I just did very recently at the ICC, where it involved a complex accounting issue, where the right provider was to take the asset, their nuclear power plant in China, was to be purchased over at the written down value. Suddenly, the party selling it came up with a ridiculous amount. And so this was debated upon, and two sets of accountants were espousing the causes of the computation, and a third accountant sat there listening to this whole dispute. And we sat in adjudication and made the award. So this is why it's specialist area. Now, Jude Benny made a vital point there in regarding the jurisdiction, which is my area. Please, for goodness sake, when you are doing a cut and paste job, even if you are managing director or legal director shouting at you all, this has been done day before yesterday, dig your heels in and say, look, I have to be careful. Now, there's a case I did, some of the parties are still here, where they were in Sri Lanka, the other party was in India, and where do they agree to the arbitration? In England. Imagine from here in the middle of the subcontinent, you can go to Singapore, you can go to Malaysia, you can have it in India or Sri Lanka. No, they've agreed. Once you sign on that dotted line, you have to follow it. So you have to be very, very, very careful when you draft that agreement. Be bold enough, stand up to the bosses and say, sorry, chum, sorry, sir, I'm not doing it. You will blame me later. So it's very, very important to know that jurisdiction part of it. And to be honest, I would also suggest, yes, I'm wearing the ICC hat myself, and institutionalized arbitration. The ad hoc arbitrations are a dismal failure. This Gedara Gamang kind of arbitration doesn't work here. You spend far more time on an arbitration and money. By the time the award is made, it's not worth the powder and shot. Quite often the argument is trotted out to us saying, yeah, but the poor client, he can't afford it. Yeah, but hang on a minute. If that poor client has to buy a car, he'll save up money, isn't it? If he has to go for a bypass operation, he'll save money for that. If he's waiting for his son or daughter, he'll save money for that. So likewise, if he's told, okay, 5 months down the road, you'll have 5 days of arbitration hearings, this is our fee, then you go ahead for that. And certainly where the institutions are concerned, there's a time frame for that. ICC has excellent supervision bases. I know I've sat on panels where we have fined the arbitrator for delaying it, despite excuses being given. Sometimes we've sent the arbitrators back, the award back to check out 1 or 2 areas. So that's why I would suggest, and you get a end product that way. So that's that part of the jurisdictional issues which I would deal with, and then come into another point. Now, how on earth do the 3 arbitrators you have appointed get jurisdiction to hear a dispute? Now, we all know, you all know, in the Civil Procedure Code, I believe section 9, I think, says, where the defendant resides, where the cause of action arose, the contract sought to be enforcement was made, etc. Now, 3 guys seated here, like 3 blind mice, how do they get their award? That is by the reference. One party will write down saying, okay, take a construction arbitration, which I note down. Claimant will say, oh, our bills were not paid. The mobilization advance was delayed. We were not given a greenfield site. And yes, some bills were paid, but they always deducted about 25% from that bill. The respondents would say, yes, the bank guarantees were not given by them on time. There was defective workmanship. And oh my goodness, there was delays. And there was a high staff turnover, work was not being done for several days, there was poor quality stuff going on, and we are claiming liquidated damages. So it's basically the jurisdiction is vested on those 6 or 8 limited areas which have been referred to the arbitration. That is very, very important to know that. You can't go outside that. Cost escalation, sorry, not referred to, you can't do that. Interest, not asked for, sorry, not referred to, you can't go into those areas. It's very important. It's very limited. See? Then also what is important is the interpretation of the arbitration clause. Quite often it's the defendant that raises the question, having initially sent his points down for arbitration. He says, oh, no. This you can't hear. This has to be heard in court. It's amazing, isn't it? Quite often it's the defendant that moves for adjournments. It is the defendant who falls ill. So it is the defendant who raises all these problems. And this was a vexed question even in the UK till to decide in the House of Lords in the Fiona Trust versus Privilove case in 2007. I would suggest to the young lawyers here, I won't tell, you can turn the pages of any arbitration book and find out about the Fiona Trust case. It laid down the foundation of the one-stop shop concept. What happened there was charter party entered into. There were several charter parties. Suddenly the owners got to be in their bonnet, whatever, and said, oh, there was bribery, there was fraud in inducing these people to get into this contract. I'm rescinding this contract, I'm going to courts. The respondents took the position, hey, hang on a minute, there's an arbitration clause. We have to go to arbitration. Though the initial Chancery Division held with the owners, the House of Lords held, the time has come for a fresh start to be made to the construction of arbitration clauses. Such construction should start from the assumption that the parties, as rational businessmen, were likely to have intended any dispute arising out of the relationship into which they had entered into or purported to have entered into to be decided by the same tribunal. The clause should be construed in accordance with that presumption unless the language made it clear that certain questions to be answered elsewhere. So, if you all have a construction of an arbitration clause, don't overanalyze it. It is very simple. Take the language as it is. If it says arbitration, bang, it is arbitration. Don't get fooled by the red herrings they are drawn. Well, defendant always likes to postpone the evil day. So that is why they put a stop. It's a very simple judgment. Anyone can read it. It's not complex. But he reviewed all the earlier judgments, and this is the Grundnorm of the one-stop arbitration cases. Having said that, in enforceability, Jude Benny dealt with that. I know there's a case where, again, we made an award for a party, and now it's 6 years since the claimant is trying to enforce his award. It went before the Commercial High Court, who held against it. Now it's lying somewhere in the Supreme Court, still not supported. And so the claimant is waiting for his award. You see, what has to be stressed is, these where training comes in, just Priyantha Jayawardhan brought it up, Tejas brought it up. Training is very, very essential. I myself was under that misconception those days, that heavens, 3 people deciding it, they can make a mistake. So we must have the right of appeal. No, that doesn't work that way. Once you have decided on a course of arbitration, the judgment, the award made by the arbitrators is final and conclusive. It's only on very, very limited areas that they can go up to. You see, I don't blame the poor judges. They are not aware. They feel they are sitting in review of everything. No, it's on very limited scope. They're outside the jurisdiction, where I told you about the 8 matters there and they went across it, or else it was against public policy. They heard about it. Those are very limited areas. And he can easily dismiss that in chambers. I'm still told lots of cases pending there still. So that's where I suggest that this training is a must, maybe specialized training for the judges and others to be done. So I would earnestly appeal for Tejas. You can stop by here in Sri Lanka more often and help out with that aspect rather than being there. So thank you very much for your patient hearing. Good luck for the rest of the session. Thank you.
Thank you, sir, for those enlightening points. And now we move on to our next international speaker, Mr. Anand Majmudra, who was enrolled with the Bar Council of Gujarat, India, as an advocate since 1989. He founded Anand Majmudra and Associates Advocates and has been practicing in arbitration, banking, civil, corporate, commercial, property laws, intellectual property laws, besides in other business laws since 1989. Mr. Majmudra has been advising foreign and Indian corporations, banks and institutions in handling litigation and non-litigation matters. He has held positions as an independent director on the board of Indian and foreign companies and the board of the Indian Stock Exchange. He has also served as a member of the Ethics Committee, formed under Indian regulations to ensure that risks for participants at clinical trials of new drugs developed are responsibly managed. Today, he joins us to speak to us a little bit on arbitration in India.
Hello, everybody. Honorable Mr. Justice Jayawardhan, Chairman ICC Sri Lanka, distinguished speakers, and the guests here. It gives me immense pleasure to be, part of this gathering. I have been to Sri Lanka a couple of times earlier, but this time I must say this visit was a great learning for me. All the speakers so far, they spoke about the ICC arbitration in Sri Lanka, and it was a great learning and indeed pleasure being with you all. I have a very small presentation on the laws applicable in India to domestic arbitration as well as to the international arbitrations. Basically, as Mr. Benny explained, the real pain of the litigant begins when the award is out. When the award is, even if it is in favor, the real pain begins, that how to enforce this award. Enforcement is a big challenge. Apart from the enforcement, it takes many, many years, and as per Indian laws, the enforcement is done in the court of law. Now, this is the historical background. If you see the background, historical background, India had this 1899 Act, which was later on repealed, and 1940 Act was introduced. Under this 1940 Act, the biggest problem was that there was too much of intervention by the court. At every stage, parties used to go to the court, and in the process, the arbitration proceedings would take more time than ordinary suit before the civil court. Therefore, this 1940 Act was not a big success. But still, wherever there were agreements and wherever the parties were bound by contractual provisions, the parties were forced to go to the arbitration. However, the parties were discouraged to adopt arbitration agreement in their contracts. 1996 was the latest law. So 1940 Act was repealed and 1996 Act was introduced. And I heard Honorable Mr. Justice Jayawardene, and when I heard him, I realized that law in Sri Lanka and law in India, they are almost identical, almost same provision. But even this 1996 Act had certain difficulties. If you see the successive amendments which were brought in between after 96, the first amendment was brought in the year 2015, 2019, and 2021. These last three amendments changed the arbitration proceedings completely. The law is updated very quickly in succession just to meet with the demand of law, demand of parties, demand of business, and to suit the industry. Now, why arbitration? All of us understand what is the reason, what is the relevance, but the most important feature is that these stringent rules of evidence and rules of the civil procedure. We also have the similar civil procedure code in India, which is applicable in disputes before the court of law. Now, those stringent rules under Evidence Act and under Evidence Civil Procedure Code, they are not applicable, and arbitrators are free to frame their own procedure. So that is the flexibility which is given by the Arbitration Act. And the most important is finality of decision. Now, Mr. Beni just mentioned that every litigant in an international arbitration would wait for an opportunity that the other party comes to his own country. When the party comes to his own country, again the real pain begins. So that was a very painful process for a foreign party to go to another land and enforce the award. Now, we have in India, apart from ICC, of course, ICC is well known, so, and Tejas has very lucidly explained what they do and how they do, and he also candidly mentioned that it is expensive than Sri Lanka, and India is included. Because, so for all those parties who are not willing to go to ICC for whatever reason or because of the cost aspect, for them, LCIA has its center. Singapore International Arbitration Center has two centers in India. One is at Mumbai, the other one is at Gandhinagar. Gandhinagar is our state capital, where I come from, Gujarat, and Gandhinagar is our state capital. And our current Prime Minister used to be Chief Minister in Gujarat. So there they have developed this GIFT City, and GIFT City is a SEZ. GIFT City SEZ also has this SISC center, which is doing very well. Apart from that, these are the international centers, established institutional arbitrations, established by various bodies. This MCIA has pan-India expansion. It is Mumbai International Arbitration Center. It has presence at 3 places: And this New Delhi Arbitration Center is also very widely accepted by parties. Now, we will very quickly go through these amendments in 2015, 2019, and 2021. So these are the three amendments which are very, very critical. The first is 2015 amendment. Under this 2015 amendment, the scope of appeal was reduced. Under Indian Arbitration Act, earlier this was known as challenge procedure, and the challenge procedure was by way of an appeal to the district court. In that appeal, the grounds were restricted, curtailed. Again, there was an amendment in 2019. The only ground available now is that the award is challenged on the ground of fraud. Only one ground. Earlier, there were several grounds that against the public policy of India, against the laws of India, etc. Now, only fraud is the only ground which is available to a litigating party, which makes the task of the succeeding party very easy in the process of enforcement. Moreover, timelines have been introduced for the proceeding itself and even to dispose of the appeals. Most important is this 36 subsection 3. 36 subsection 3 is made retrospectively applicable. 36 subsection 3 provides for the grounds for challenge. Apart from that, the qualifications and experience of the arbitrator have been now qualified. Amendment to section 34, the challenge procedure, takes away the majority of the disputes, and only if the fraud of which for which the record is available on the proceedings. So therefore, fraud has not to be pointed out only by articulating arguments, but the fraud must emerge from the arbitral records. So that is the now new legal requirement, that the party challenging the award will have to show, based on the record, that how fraud was committed and who committed fraud. Under section 37, this is a very major amendment. Earlier, this used to be an appeal. Now the appeal word has been struck down, and this is only a challenge procedure challenging the award order passed by the district court under section 34. Under 37, again, the scope is extremely limited, and the court is required to see only whether the fraud was committed by the party, and the court has erred in appreciating the evidence on record. Now, this part IA, it's a new part inserted, which is Arbitration Council of India. It's a very good initiative taken by Government of India. And the fourth schedule prescribes the model fees, which is again a very, very useful amendment, because all fees are prescribed by the statute, applicable in case where, depending upon the stakes involved and the claim amount, the table is prescribed in the fourth schedule, which sets out the fees payable or by the parties to the arbitrator. Now, enforcement is, as we understand, is the key area. Now, power of judicial authorities to refer parties to arbitration. So, whenever there is an arbitration agreement, and if any of the contracting party approaches court instead of approaching the arbitrator by way of a frivolous litigation, by way of harassing the foreign contracting party, or for any other reason, then the courts in India have power to refer the parties to arbitration under section 45. Now, this power to refer to arbitration is provided under 45 as well as 54. Both these sections, the first section pertains to the disputes or arbitrations arising out of New York Convention, and the second provision applies to the arbitration arising out of Geneva Convention. The binding force, again, is very important, that whether the award would be binding upon the parties on a foreign land. Section 46 of New York Convention and 55 of Geneva provides that the award is binding to all the parties, including the litigating parties, and the courts will also consider award as enforceable award for the purpose of validity of the award the laws applicable in the country in which the arbitration proceedings were conducted, of course subject to contractual requirement. If the contract requires that the laws in Singapore would apply or laws in Sri Lanka would apply, then subject to that, but then all those laws will be respected by courts while enforcing the award. The courts in India would not look into the legality, propriety, reasoning and the justification given by the arbitrator, because the court therefore would not see it as court in appeal. Court will simply see whether the legal requirements of the land have been complied with or not. This is a very major development, because earlier people used to challenge, the appeal would become even longer than the arbitration claim. Now foreign awards are now considered as decree made by the court of law for the purpose of enforcement. So no court will go behind the award and evaluate the correctness, justification, propriety and reasonableness of the award. The courts are forbidden from substituting their judgment. Courts are forbidden from replacing the interpretation of the evidence, interpretation of the law. Courts will only see whether the award is passed. The arbitrator has followed the applicable laws. Once it is established that these two answers are in affirmative, then the court will straight away enforce the award. Now, arbitration in India, like any other country, is a very effective remedy. Now we have in India, under Indian Arbitration Act, timelines prescribed by the statute. The High Court appoints arbitrator. Arbitrator cannot extend the validity of when the time expires. All arbitrations are time bound. Within the timeline, if the proceedings cannot be completed for some reason, then the arbitrator has jurisdiction to enlarge the timeline only once. If there is a necessity to enlarge the timeline again, then the parties have to again go to the High Court. High Court will evaluate why this could not be completed, what progress. So therefore, there is an element of supervisory jurisdiction over the arbitration proceeding. This element was not there earlier. So the High Court will then see that whether the arbitrator has, High Court also will replace the arbitrator if required, in case if the arbitrator concerned has not been able to perform for personal reasons or other reasons. Then therefore it has been now made time bound, timeline fixed by statute. Arbitrator can extend the limit only once. Ease of enforcement and limited scope of challenge. Enforcement is same on the basis of decree of the court of law. So these are the reasons why it is a most preferred remedy. So before I conclude, I would thank ICC Sri Lanka and the chair ICC Sri Lanka for giving me this opportunity to be here with this August gathering and share my views. Thank you very much.
Thank you, sir, for those invaluable comments. Our next speaker, Dr. Harsha Cabral, President's Counsel, is a veteran legal professional with a wealth of experience and exposure both in the local and international arenas. Dr. Cabral is a President's Counsel in Sri Lanka with 35 years of experience in the fields of intellectual property law, company law, commercial arbitration, securities law, and international trade law, covering both criminal and civil aspects. He has been a President's Counsel for 17 years and commands an extensive practice in the commercial high courts and Supreme Courts of Sri Lanka. He holds a doctorate in corporate law from the University of Canberra, Australia, and was a sitting member of the International Chamber of Commerce International Court of Arbitration in Paris for a period of 6 years until 2021. He is a representative member of the Federation of Integrated Conflict Management, as well as a representative member of the International Commercial Disputes Tribunal. Dr. Cabral is also a Fellow of the Institute of Chartered Governance Institute, UK and Ireland, and was the founder and board member of the Sri Lanka International Arbitration Centre, in addition to being involved in the drafting of the Arbitration Act No. 11 of 1995, which is the current law in place. Dr. Cabral is also a member of the Law Commission of Sri Lanka. a member of the Intellectual Property Advisory Commission of Sri Lanka, and the chairman of the Intellectual Property Law Reform Project of the Ministry of Justice. In addition to being a member of the Corporate Governance Faculty and the Corporate Governance Committee of the Institute of Chartered Accountants of Sri Lanka, and is also a nominee of the University Grants Commission on the Postgraduate Institute of Medicine. As a member of the Advisory Commission on Company Law in Sri Lanka, Dr. Cabral was one of the architects of the Companies Act No. 7 of 2007, which is the current act. He also serves as the chairman of Tokyo Cement Group and of National Savings Bank. He was the past chairman of LOLC Finance PLC, a director of LOLC Insurance Company Limited, Commercial Leasing and Finance Limited, Richard Pierce Distributors Limited, and acting chairman of Hatton National Bank PLC. In addition, he was a senior director of the Union Bank of Sri Lanka. Dr. Cabral was also a member of the Cabinet-appointed Committee on the National Trade Policy and also a member of the Presidential Commission appointed on reformulating the laws of Sri Lanka. And today we are privileged to have him here to discuss the disadvantages and advantages in commercial arbitration.
My good friend Justice Priyantha Jayawardena, all the justices, President's Council, my dear friend Manil Jayasinghe, one of the pillars in the corporate governance field, Director General of Intellectual Property, President of the Chairman of the ICC, distinguished foreign delegates, the previous speakers, especially my dear friend Mr. Dinal Phillips. I managed to follow his final part, tail end of the speech. Fellow attorneys, I see some of my students, and members from the corporate field, ladies and gentlemen. It gives me great pleasure to come here and speak a few words on commercial arbitration. And I'm thankful to my dear friend Shanil for inviting me. And this is one area I really have taken a liking. And I was involved in drafting the Act in 1995. And also, I have been an arbitrator. Now, of course, I don't go as counsel in arbitrations, except in few international arbitrations. Mostly, I go as arbitrator. And again, now, mostly as chairman of tribunals. And as a writer on commercial arbitration, I had the privilege of studying most of the advantages, disadvantages, and also the downfall of commercial arbitration in Sri Lanka, especially when we started in 1995 with a different agenda. I think Justice Jayawardena knows way back in 1995 when commercial arbitration was introduced the proper way with the introduction of the new act. There were several workshops and training courses specially tailored for us by the Stockholm Stock Exchange and the Swedco, which helped us to get a new law. Unfortunately, the judges who were trained in the workshops, I see only a very few left, and the counsel who were trained and the corporate leaders who were taught, unfortunately, most of them have left. So in a new field of commercial arbitration, we see a huge lacuna, and it's not a success story to be dealt with anymore. Now, I would first just briefly explain what the advantages are, then deal with the disadvantages, and maybe in our session we have to discuss what has gone wrong in commercial arbitration in Sri Lanka. Now, in fact, there's a little book on commercial arbitration I published a couple of years back, and in that I have a particular area where I deal with commercial arbitration, the advantages and disadvantages of commercial arbitration specifically, and I would briefly touch on those, especially to highlight what exactly the role of commercial arbitration vis-a-vis Sri Lanka is. Let me briefly run through so that saves time. In chapter 17, I just say advantages and disadvantages of arbitration. The advantages: party autonomy is a hallmark of commercial arbitration. This indeed is visible in Sri Lanka as the golden thread that runs through the statute. Well, the statute is only 50 sections. Anyone can just read and understand. One of the tiniest pieces of legislation one could find, especially for the non-lawyers. Parties are free to appoint their own arbitrators. Parties are free to agree on the arbitration agreement, either in the main contract or as a separate agreement. Parties are free to agree whether arbitration should be institutional or ad hoc. Parties can agree on an institute that is cost-effective. Parties can agree on an institute that is efficient. Parties are free to agree on the substantive law that is applicable to the arbitration. Parties are free to agree on the procedural law that is applicable to the arbitration. Parties are free to agree on the place of arbitration or the seat of arbitration. Parties are free to agree on the language of arbitration. Parties are free to agree on the procedure to be adopted in arbitration. Parties can agree that the provisions of the evidence ordinance shall not apply to arbitration proceedings. Parties can agree that the arbitrator or arbitrator shall only be civil engineers or lawyers or non-lawyers or any other persons with a particular expertise. Parties are free to agree on the time frame of the arbitration. In certain instances, parties can even agree on expedited formulae on arbitration. Parties can agree on an exclusion agreement whereby the parties are bound not to appeal beyond the High Court to the Supreme Court, either after enforcement proceedings or setting aside proceedings. Whilst parties decide on its arbitrators, they can rely on the expertise of the arbitrator on the subject matter, namely legal, commercial, technical, expert, etc. Party-nominated arbitrators can rely on such expertise when appointing the chairman of the tribunal. It is not necessary to appoint attorneys at law or retired judges as arbitrators. If the subject matter in dispute is related to construction, the tribunal can consist of arbitrators from such construction field. It is, however, advisable to have at least one member of the tribunal with a legal background. Arbitral proceedings move faster than court proceedings, which enables disputes to be resolved within a shorter time period. Arbitral proceedings are confidential, and thus information about the dispute, the persons involved, the evidence, led, oral, and otherwise, will not be exposed in the public domain. It is said that contractual parties in the commercial world would prefer washing their dirty linen in private than in public. Confidentiality and privacy are major advantages in arbitration. Cost in arbitration will be much less than in litigation. Commercial litigation is expensive in Sri Lanka and in almost every jurisdiction. Speedier resolution of disputes through arbitration can make it cost-effective. A major advantage is enforceability of the award. Once the award is made by the arbitral tribunal, parties are free to enforce the said award or set aside the said award. The enforcement process via courts makes the award a valid decree of court. The enforcement process by courts becomes more important when the New York Convention of 1958 comes into play. The recognition and enforcement of a foreign arbitral award in the member state is a definite advantage in arbitration. In Sri Lanka, judgments of foreign courts cannot be enforced as Sri Lanka does not have an enabling statute for same. The only statute on the matter is the reciprocal enforcement of foreign judgment in a magistrate's realms, which is archaic and inadequate. So these are a whole lot of plus points one could see in the process of arbitration, which you might not see in litigation in a court of law. But then, what are the disadvantages? In arbitration, the tribunal has limited powers with regard to sanctions. The tribunal cannot summon witnesses and cannot order witnesses to produce documents. The tribunal derives power by agreement of parties only. The award made by a tribunal is a mere piece of paper until such time it becomes a decree of court. A party cannot enforce an award of the tribunal without going to courts. There is no right of appeal in arbitration, unlike in courts. Mr. Dinal Phillips touched on that. If one party fails to obtain relief from the arbitral tribunal, that becomes final between parties. The rights of parties to arbitration is limited to the enforcement of the award or setting aside of the award, in addition to other rights of moving court as set down in the statute. The rights of parties to obtain interim relief is limited, unlike in courts. The enforcement of such interim relief becomes cumbersome due to delays in litigation. It is to be noted that Sri Lankan Act uses the term court or high court 61 times. There are only 50 sections, but there are 61 times the word court is used. And that poses problems, as loss delays is a major hurdle to overcome in arbitration. A minimum of 6 to 12 months or more is taken to set aside or enforce an arbitral award in Sri Lanka. If there are other applications made to the High Court prior to that, for example, regarding the appointment of an arbitrator or calling of witnesses, etc., there is a further delay, as the same amount of time is spent in court to decide on the outcome of those issues. During arbitration proceedings, the parties may make the following applications to High Court under the provisions of the Act. Section 7, appointment of arbitrator. Section 10, appeal on the challenge to arbitrator. 11, competence of arbitral tribunal. 13, interim measures of protection. 20, obtaining summons. 21, examination of witnesses. 30, delay in prosecuting claims. These, in addition to the above, under sections 31 and 33, applications can be made to enforce the award, and under section 32, an application can be made to set aside the award. Once a judgment is delivered by the High Court, either setting aside or enforcement, the party aggrieved may make a further application to the Supreme Court pursuant to obtaining leave purely on a question of law. If leave is granted, this application in the Supreme Court can take at least 3 to 5 years or even more to conclude. This is unfortunately how the legal system works in Sri Lanka. In countries such as Singapore, the same system works efficiently, and thus Singapore has prospered as one of the finest venues in the region for commercial arbitration. That indeed is the culture we need to inculcate in Sri Lanka. Unless arbitration is under specific rules, informality can affect the conduct of arbitration and the speed at which the proceedings are conducted. In arbitrations, parties have to pay cost of the tribunal and the venue, which can be sizable at times. In litigation, the costs may be far less. There is no payment made by the parties to the judge and the courts. Now, these are the pluses and minuses of arbitration, what we see in Sri Lanka under our statute. In 1995, when this statute was introduced, as supported by the Stockholm Chamber of Commerce, they gave us the infrastructure, training, all free of charge. And I must say the main architects happened to be my guru, Dr. Kanagiswaran, and Mr. U.L. Kadrugamu, senior partner of FG and Desera. Now, they sacrificed a lot of time and money, and their personal contribution was great, and we expected this to work. Unfortunately, a couple of things don't work in Sri Lanka, right? Because we know when there is trouble, there are lawyers. The same way, when there are lawyers, there is trouble. Right? So ultimately, I can say that the culture of arbitration is far from what we see in other countries, especially now what I saw in Singapore. I was impressed with your presentation, Anand, where you referred to the new amendments that have come. Even the time frame is decided by statute. Now, there are a few tinkering measures to be done to our act. Now, it's quite old, from 1995. It's quite a long time. It's almost 28 years. But it's not the wrong of the statute itself, but the players. We, the lawyers and the retired judges, with all due respect to the judges who are here, that has been the stumbling block for any development in arbitration. We do our arbitrations in the evening, because in the mornings, lawyers can't sacrifice their practice. If you go to Singapore, you know, Anand, any big arbitration can be finished in 1 week. From morning, 9 o'clock, Maxwell Chambers will sit, 9 o'clock in the morning till 5 in the evening. 5 days is enough to finish any big arbitration, huge arbitrations. Cross-examine 18 witnesses, right, online, and the control. Right? My colleagues who appear in arbitrations know very well. Arbitrators have lacked control in Sri Lanka. I'm very bold to say that. Arbitrators feel that they are under obligation to the lawyer who is appearing to get the next arbitration. You think that if you hold against them, if you are too rough on them, because very, very senior lawyers appear. They decide the arbitrators. Your next arbitration will come if you're a favorable arbitrator. Once you are appointed, when I am appointed as arbitrator, I forget from which side I have been appointed. Once you go on the bench, you know, you come from a person's chamber, but that doesn't mean that you have to look after that chamber all the time. So, in fact, my good friend, Justice Jayawardena, my President's Counsel, Liana Patabandi, we are all from the same batch, right? But he will, Justice Jayawardena will not give me an inch extra when I am before him. Sometimes I don't like to go before him because I don't get that inch, right? So, arbitrators, we have that problem. Unless you control, in international arbitrations, you know, the people who have appeared in international arbitrations know very well. If they say, okay, a main witness, okay, main witness you'll get 2 days maximum. Short witness, 15 minutes, and not a minute more. He can be the most powerful counsel who is appearing, but he won't get a minute more. Right. So that type of control we don't see in Sri Lanka. I think Mr. Phillips will agree with me. He sits with me on so many arbitrations, or the counsel would know. And like in courts, they come and ask for 3 months to do written submissions. Like in courts, they ask for minimum 3 months to 2 months for statement of claim, statement of defense, reply, affidavit. Now, commercial arbitration is based purely on documents. So you don't need that amount of oral evidence. But unfortunately, counsel would love cross-examination, oral evidence. They are paid very well, right? Sometimes more than what you earn in the courts, your evening income, right? So there is lack of control, that is something, and I blame not on the other professions. If there are engineers, architects, quantity surveyors, from 1996 we have been training, we have had a diploma in commercial arbitration at ICLP. I have been the course director from 1996 onwards to date. We have produced so many diplomates, chartered accountants, engineers, architects, quantity surveyors. Now we have overseas lectures also, Middle Eastern countries. And I'd love to see them as arbitrators. I'd love to see them as counsel. You don't have to be an attorney at law to be a counsel in arbitration. You don't have to be an attorney at law to be an arbitrator. So they come as witnesses, they know the story. But unfortunately, we have missed the bus because of this culture. So until that culture change happens in Sri Lanka, whatever new amendments or statutory changes we make, we will not succeed, because the lawyers, they are used to getting dates in courts, right? 1 hour, half an hour's arbitration is not going to change all this. It's nice to have all these seminars, discuss the pluses, minuses. 30 years ago also we discussed all this. We looked at Singapore, Maxwell Chambers Act, LCIA, London Court of International Arbitration, Dubai Court of International Arbitration. In fact, India got the act after us. They got it in 96, we got it in 95, right? They have overtaken us. You go to Dubai International Arbitration Center, Hong Kong, HKIAC, London Court of International, ICCSL, all the international arbitrations all over the world, Australia International Arbitration Center, Malaysia, all these have prospered. But we are still stuck where we were prior to 1995 when we got the new act. So without a culture change, without fixing all these problems, amending the act or any little things won't help. The mind change of the arbitrators, the practicing lawyers, and any stakeholder who comes into arbitration is essential. So we have a discussion, so I will take any question you have on local arbitration or international arbitration or any section on the Arbitration Act. Thank you very much.
Thank you, sir, for those invaluable insights.